the duties in detail. Okay, the next session is about what are the duties of the arbitrator and what are the procedural choices he has. Okay, so that we will see in detail in this session. Let me open my PPT. So this is in continuation to what I have been saying about the resilient award, because we need to remind and reassure ourselves that whatever the arbitrator is doing, that shouldn't have any bearing on the arbitration award. Okay, because all the procedures, all the happenings, the duties, powers, submissions, everything is towards getting an arbitration award. So that arbitration award, that should be very resilient. It depends upon the arbitrator's handling of the proceedings. So therefore, he must know what is his duties, what are his powers, what is his jurisdiction. Now we are going to see the duties, duties of the arbitrator in detail. And also towards the end, we will see what are the procedural choices he can make. Let me open. Okay. Okay, so it is a continuation of what we have been seeing, the jurisdiction, powers of the arbitrator. Similarly, arbitrator, he must be aware of what are his duties. He cannot, there shouldn't be any room for dereliction of duty. Otherwise, that will be a ground for setting aside of his award. So everything ends up with the award, arbitration award. So therefore, the arbitrator, he must be aware of what are his duties. Okay, now we'll see in detail. Of course, duty to act fairly means it should be in a balanced analysis. Okay, then he must adhere to the principles of natural justice. He must give equal opportunity to the parties. There shouldn't be any favoritism to one of the parties. Okay, normally the claimant, he will invoke the arbitration. There will be a tendency because since they started the arbitration and they will take care of the proceedings, so there will be apparent bias that shouldn't be there. Okay, so the arbitrator is apart from all these favoritism and all. Otherwise, there is a strong ground of lack of principle of natural justice for which there is no compromise. The award will be simply set aside. Hearing in presence of both the parties, that is very important. Duty to consider vital documents. These all we will see in detail. Okay, I'm just reading out what are the duties. Arbitrator must act within the submission. Okay, nothing more, nothing less. We will see one by one. So duties continues. Arbitrator to decide on his skill and knowledge. Okay, so that he should avoid. Of course, if he knows that there is something wrong, as I have mentioned, he can seek expert opinion. He can appoint an expert and he can derive and he can apply his skill and knowledge based on the report of the expert. Arbitrator cannot delegate his functions. If he is having, say, 10 cases, he cannot give 5 cases to his junior and do that. No, it is not allowed because arbitration is a confidential process. Therefore, arbitrator is not allowed to delegate his functions. Of course, he can delegate his function only to the tribunal secretary or the case manager. That also to some extent only. Okay. Then he can proceed ex parte that we have seen. Duty to act within the reasonable time. The timeline is very important. We will see in detail. And then proper hearing should be there as per the rules of the arbitration. We'll see one by one. Okay. Duty to act fairly. What is that? Fair and reasonable manner. He should act. Okay. There shouldn't be no undue favors to one party. Underline this. No undue favors to the claimant who is arranging everything for you, who is booking the ticket for you, who is booking the nice hotel for you. No. You should act only based on the submission in front of you. There shouldn't be any favoritism. Rules of natural justice, it must be followed. There is no compromise on that. Okay. They call it as in Latin, audi alterum partem. It means he shouldn't decide anything of his own case. If there is a dispute related to his relation, then he must recuse himself. In simple terms, there shouldn't be any conflict of interest. He cannot be a judge on his own case. Okay. And he must give equal opportunity to present from both sides. Adherence to principles of natural justice. So these are the cardinal rules, when it comes to principles of natural justice. What are they? Each party must have a full opportunity to present his own case. You shouldn't give one party more opportunity to another party, lesser opportunity. No. If you demonstrate that, then your story is over. And it is a small world. When you make 10 awards, out of 10 awards, if 5 awards is set aside, then nobody will come to you. It is as simple as that. Therefore, there shouldn't be any compromise on such things. Each party must be aware of his opponent's case. Okay, it is like, whenever a submission is made, it should go to the respondent also. It should not only come to arbitrator. So the arbitrator, he must make sure whether it is copied to all the parties. The parties must be treated alike. Each must have the same opportunity to put forward his own case. Okay. Hearing in the presence of both the parties. It is not like, okay, Mr. Clement, you come to my room, let us have some chit chat. Hi, hello. It is not allowed. It should be in the presence of both the parties only, unless the other party is absent. You gave sufficient notice, but the other party is absent. That is a different story. But when both the parties are actively participating, then you cannot conduct your case in the absence of one party. So this is the judgment, landmark judgment. When the arbitrator accepts documents from one party in the absence of the other party, the arbitrator would be guilty of misconducting the proceedings. Okay. So his award will be set aside. Duty to consider vital documents. This is another important area. What are the vital documents? Of course, the arbitration agreement, contract document. It implies one thing very clearly. Before the start of the arbitration, validation of document should be there, whether all the vital documents which are controlled in nature are in place. That should be the first step. after the commencement of the arbitration. That is what we do. You cannot consider some photocopy, some unclear copy. You cannot base your decision on such unclear or uncontrolled documents. If there is no arbitration agreement, or if the arbitration agreement is not clear, or if the contract document is not clear, then he must insist on that. Just give me a second. Madhu, hope I'm audible, Madhu.
Yes, sir.
All right. Okay. So therefore, consideration of vital document is paramount in deciding the dispute. And then he must act within the submission, what is in front of him, even if he knows that there is something wrong. But if it is not submitted to him, he shouldn't make any decision. So that will be kind of straying beyond his boundary. That is not allowed. Okay. So these are the essential elements of an arbitrator while conducting the proceedings. I mentioned he cannot delegate his function to others. Okay. Arbitrator cannot. Hello. Okay. Arbitrator, he cannot refer their arbitrated men to whom no submission was made. Okay. It will amount to breach of confidentiality and serious misconducts. Strong ground for setting aside of his awards. In certain jurisdictions like UAE, you must be aware that arbitrators misconduct is a criminal breach. They may be put behind the bars. Okay. So it is as simple as that. Therefore, there shouldn't be even an iota of deviation on these aspects. You must know what is your jurisdiction, where you are, what the law says. Irrespective of this, we shouldn't take any chance on these matters. Misconduct is a very serious breach. Integrity is the hallmark of the arbitrator. Becoming an arbitrator is not a big deal. If you do certain courses like CRB and all, and if you represent few cases, you can become an arbitrator. Becoming an arbitrator is not a big issue, but remaining as an arbitrator is very, very important. How you will remain as an arbitrator? Only when you maintain your integrity. What is integrity? Be honest when you are alone. Being honest in the presence of others, that is different. But when nobody is noticing you, remaining honest, that is the integrity. So that is what is the important ingredient of an arbitrator. That is what will be reflected in these situations when somebody is accusing you of misconduct. Okay. So therefore, this is very, very important aspect. So this we have already seen, power to proceed ex parte. Duty to act within reasonable time. This is another vital aspect. Again, here we should know what is your jurisdiction. What is your geographical area? If you are in countries like India, or if you are dealing with a case involving Indian parties, Indian Arbitration Act, it stipulates mandatory timeline of 6 months plus 12 months. 6 months is for the submission and 12 months is for the arbitration award pronouncement. So therefore, the arbitrator, he has the bounden duty to deliver within this timeline. When it exceeds even by a day, he loses his mandate by default. It is, there is no compromise on that. It is as far as India is concerned. Whereas in UAE, even though the law, it doesn't specify the timeline, but all the arbitrations by default, it happens through the institutions. And the institution, they stipulate even more stringent timeline, unlike countries like India. So here, once the pleadings are over, once the submissions are over, the arbitrator is given only 1 or 2 months to deliver their award. So therefore, the arbitrator has the bounden duty to deliver within the stipulated timeline. Okay, there is no compromise on that. Duty towards proper hearing. The hearing should be in a proper manner. What are the requirements of a proper hearing? Each party, they should get the notice. Okay, the notice should be served in a proper manner. You are just sending an email to an email ID which doesn't exist and it is getting bounced. You shouldn't keep quiet. You should try the other available email IDs, or you should try for physical delivery. So the serving of notice is very, very essential aspect of the arbitration proceeding. If there is a failure, then your arbitration award will be set aside. Each party must have a reasonable opportunity to present. Okay. Each party must have an opportunity to be present throughout the hearing. Okay. Each party must have a reasonable opportunity to present statements, documents, evidence, and arguments in support of his own case. He shouldn't deny any opportunity. Each party must be supplied with a statement, documents, and evidence adduced by the other side. That already I have mentioned. The copies should be served for all the parties involved. Each party must have a reasonable opportunity to cross-examine. Cross-examination is another hallmark of arbitration. When you produce a witness, that witness must be allowed to be cross-examined by the respondent side. Okay, so that should be allowed. Vice versa. If they produce a witness, then you will be allowed. So these are the duties of the arbitrator. Each party to arbitration reference is entitled to advance notice. Okay, that we have already seen. Then we will quickly see what are the procedural choices available to the arbitration tribunal. Conduct of proceedings. When the arbitration agreement is silent, or when the arbitration clause is silent, or when the parties, when they don't agree on the conduct of proceedings, then the arbitrator, he has the power to decide how the arbitration proceedings should be conducted. Okay. And the next one, determination of jurisdiction, whether he has a jurisdiction or not, that he only can decide on that. And what is the other procedural choices? Interim measure. When there is an urgent requirement to protect the asset or to freeze an account, then they have the procedural choices to issue the interim orders. Okay. So this we have already seen, just to re-emphasize. Interim measures also we have seen for protection of assets, okay, or to provide appropriate security, the interim award can be produced. Also, the emergency arbitration. So that is also part of this aspect, the interim measure. In certain cases, what happened? There must be an emergency requirement. Then the emergency arbitrator will be appointed. Okay. So these are the various aspects of the duties of the arbitrator, and what are the procedural choices he can make.